Welcome! We're happy you joined us today for the U.S. Department of Education's presentation on the equitable services provisions of the Individuals with Disabilities Education Act. My name is Pamela Allen, and I am with the Office of Non-Public Education. The department is committed to supporting the effective implementation of the equitable services requirements for private school students under IDEA. And to support this, we promote state educational agency and local educational agency accountability for the provision of those requirements for eligible private school students. I'll give you a little bit of background about ONPE and equitable services. And since the initial passage of the Elementary and Secondary Education Act, also known as ESEA, in 1965, private school students and teachers have been eligible to participate in certain federal education programs. As such, ONPE's mission is to foster the maximum participation of non-public school students and teachers in federal education programs and initiatives, including IDEA. Let's go over the learner outcomes for today's session. After attending the session, you'll leave with strategies to accurately locate, read, and interpret IDEA regulatory provisions, knowledge and resources to enhance your effectiveness when working with LEAs on IDEA-related matters, and increase confidence to engage in timely and meaningful consultation with LEAs. Let's provide a little bit of background about IDEA. It's the federal law that ensures that all children with disabilities receive a free, appropriate public education. IDEA provides benefits and services to children with disabilities in public schools, as well as in non-public schools, including private and religious schools. So let's start with how to locate and navigate the IDEA regulations, which will give you a greater understanding of what the provisions are. Navigating regulations is not as difficult as what it might appear on the surface. The regulations are basically listed in numerical order within each section. And simply just click on the image on this slide or type idea.ed.gov into your search engine to navigate to the web page where all of the regulations are located. So the web page looks like this. And once you're there, hover over the Law and Policy tab and select the item that says Statute and Regulations. So this would be a good time to pause and go ahead and do that. Once you're on that page, select the Regulations tab and scroll down and click the first bullet under the Viewed Indexed IDEA Part B Regulations. And you can see there's an arrow pointing to that. If you need to pause to get over there, go ahead and do that. So in this presentation, we'll focus on the regulations in the Children in Private Schools section, which are located in Subpart B, State Eligibility. This would be a good time to pause if you'd like to navigate over to the Subpart B regulations. Just click that link, it's hyperlinked right to it. Once in the Subpart B regulations, scroll down to the Children in Private Schools section, which are located in the regulations from Section 300.129 through Section 300.144. And as you can see here, all of the regulations are written in numerical order. So just scroll through the regulations by their number to locate the item that you want to review. Now let's go ahead and navigate over to Section 300.131, which is the child fine regulation. And we'll talk a little bit more about how they're organized there. So click that link. Well, let's take a minute to talk about how to actually read the regulations. And depending on how a regulation is written, sometimes you'll see the abbreviation SEC as is written down here on this regulation, and sometimes you'll see the symbol as is written up here. Both mean section, where a particular regulation is located within the larger body of regulations. In this particular one, it's Section 300.131. Anytime you use two of these symbols together, as is up in the heading, it indicates there is more than one regulation being cited. So what's written here, we're referencing sections 300.129 through sections 300.144. In this particular regulation, there are also paragraphs and subparagraphs, and those are indicated by letters and numbers, similar to how you would see and might use in a bulleted list. So let's take a look down here. You can see paragraph A, paragraph B, paragraph C, D, and E. And in paragraph B, there's also subparagraph B1 and B2. So if we were to take a look at section 300.131A, we would look at the first paragraph here. Now, some paragraphs, like this one, also contain cross-references right here. These cross-references are very important because they connect you to other related regulations that help you understand the meeting in its full context. So anytime you see that, you would want to go ahead and explore that and jump to those regulations on the idea.ed.gov website. Now, before we move on, let's talk about the definition of the population of students that we're talking about, parentally placed private school children with disabilities. In general, when a child is enrolled in a private school by his parents, because they have made an independent choice to do so, for the purposes of IDEA, the child is considered to be parentally placed. This regulation is located at 300.130 and is also in subpart B. The cross-references in this section are related to definitions of elementary and secondary schools. And those two regulations happen to be located in subpart A of the regulations, so I've hyperlinked them here for your convenience. This would be a good time to hit pause, click the links, navigate over to the regulations so that you can see the actual regulation of the definition of a parentally placed private school students with disabilities located at section 300.130, and then you can link over to the cross-references for the definitions of elementary and secondary school. I also want to point out that at the bottom of most of our slides, you're going to see a citation. You'll see the citation for the actual regulation that's related to it, and you're going to see a statutory citation as well. For the purposes of this presentation, we'll cite regulatory citations, and we'll stay with that. Now, people often wonder which LEA is responsible for ensuring equitable participation. And section 300.131 requires that the LEA must locate, identify, and evaluate all children with disabilities enrolled by their parents in private, including religious, elementary and secondary schools located in the district that is served by the LEA. IDEA requires that the LEA, after timely and meaningful consultation with the private school officials and with representatives of parents of parentally placed private school children with disabilities, that the LEA conduct a thorough and complete child find process to determine the number of parentally placed children with disabilities attending the private schools located within the LEA, regardless of where those students live. Additionally, section 300.132, which is also referenced at the bottom of this page, along with 300.131, 132A makes clear that to the extent consistent with the number and location of children with disabilities who are enrolled by their parents in private schools located in the school district served by the LEA, that provision is made for the participation of those children. These requirements make clear that the obligation to spend a proportionate amount of IDEA funds to provide services to children with disabilities enrolled by their parents in private schools lies in the school district served by the local educational agency. Now let's talk about the IDEA basic requirement for the provision of equitable services, which is located at section 300.132. The amount of Part B funds available for these services is based on the proportionate share calculation, which we'll discuss later in this presentation. It's important to note that timely and meaningful consultation must occur before any decisions are made that will affect the participation of parentally placed private school children in Part B programs. Thus, decisions about services may not be made in advance or in the absence of timely and meaningful consultation. We'll talk more about this in a little bit. After timely and meaningful consultation has occurred with private school representatives and representatives of parents of parentally placed private school children with disabilities, the LEA is responsible for making final decisions about all aspects of the services to be provided to parentally placed private school children with disabilities. On this slide, you can see there is a link to the basic requirement at 300-132, and there are also some cross-references that we're linking to you at 300-137 and 300-134. You might want to pause right now to take a look at those cross-references and link over to the basic requirements if you have an interest in doing so. Consultation is an incredibly important part of ensuring that IDEA equitable services are delivered as the law intends. In IDEA, consultation is a mandatory process that involves discussions between the LEA, private school representatives, and representatives of parents of parentally placed private school children with disabilities on key issues relating to the equitable participation of such children in federally funded special ed and related services. Each LEA, or if appropriate an SEA, must consult in a timely and meaningful way during the design and development of special ed and related services for parentally placed children with disabilities. A unilateral offer of services by an LEA with no opportunity for discussion is not adequate consultation, as such an offer does not meet the basic requirements of the consultation process. Only after discussing key issues relating to the provisions of special education and related services with all representatives may the LEA make its final decision with respect to the services to be provided to the eligible private school children with disabilities. Throughout the consultation process, there are topics that are required points of consultation. The first is located at 300-134 and addresses the child find process in paragraph A. IDEA requires that the LEA, after timely and meaningful consultation, conduct a thorough and complete child find process to determine the number of parentally placed children with disabilities attending private schools located within the LEA, regardless of where those students live. The child find requirements for parentally placed children make clear that the LEA, after timely and meaningful consultation with private school representatives, must conduct a thorough and complete child find process to determine a number of parentally placed children with disabilities attending private schools located in the LEA. And child find is an ongoing process. So if a child enters a private school without having been previously identified as a child with a disability, and he is suspected of having a disability during the school year, the LEA, where the private school is located, is responsible for ensuring such a child is identified, located, and evaluated. In addition, it is possible that a child who was previously evaluated and determined not eligible for special education-related services by another LEA may in fact be determined eligible for special ed and related services at a later time through the child find process conducted by the LEA where the private school is located. Well, let's talk a little bit more about the child find regulation. As you've learned under 300-131, the LEA where the private school is located is responsible for conducting child find for parentally placed private school children. And the LEA in particular is responsible for locating, identifying, and evaluating all children with disabilities who are enrolled by their parents in private, including religious, elementary schools and secondary schools located in the LEA. The LEA also has an obligation in conducting child find for permanently placed children with disabilities to undertake activities similar to activities undertaken for the agency's public school children. The child find process must be completed in a time period comparable to that for children attending public schools in the LEA. And the LEA, where the private school, elementary or secondary school is located, has a number of options as how to meet its obligations under child find. For example, an LEA may assume the responsibility itself. It might contract with another public agency, including the public agency where the child resides, or it may make other arrangements for contracting with a third-party provider to conduct child find activities. Importantly, though, an accurate count of the number of eligible private school children with disabilities enrolled by their parents in private schools located in the LEA is needed to calculate the proportionate share of Part B funds that the LEA must expend annually for services for permanently placed private school children with disabilities. And there is a distinction under IDEA between the obligation to conduct child find activities, including individual evaluations for permanently placed private school children with disabilities, and the obligation to use an amount of funds equal to the proportionate amount of an LEA subgrant to provide special ed and related services to this population of children. The obligation to conduct child find, including individual evaluations, exists completely independently from the obligation to provide equitable services. The costs of child find activities, such as evaluations, may not be considered in determining whether the LEA has spent a proportionate amount on providing special ed and related services to permanently placed children with disabilities. And finally, the child find provision at 300-131F makes clear that the LEA where the private elementary and secondary schools are located is responsible for conducting child find, including the individual evaluations of all permanently placed private school children suspected of having disability enrolled in a private school in the LEA, regardless of where those children reside. And this includes all children from other states who may be attending a private elementary school or secondary school located in the LEA. And let's jump over to the record-keeping regulation quickly. The regulation that's located at 300-132 paragraph C requires the LEA to maintain in its records and provide to the state the number of permanently placed private school children that have been evaluated, the number that have been determined eligible, and the number served. The LEA must provide this information to the state each year. Now let's go back to the required consultation topics. Another one of the required topics involves a determination of the proportionate share of federal funds available for services under 300.133B. This includes a discussion of how the proportionate share was calculated. So this regulation, as you can see, is located, let's get the highlighter going here, at 300.134B in the consultation provisions, but it has a cross-reference to the provisions about the proportionate share located at 133B. So it's important to connect these two together. Now, the revisions to IDEA that were made in 2004 made a significant change in the manner in which the proportionate share was calculated. So under the 2004 amendments to IDEA, the proportionate share calculation must be based on the total number of children with disabilities who are enrolled in private schools located in the LEA, whether or not the children or parents reside in the LEA. So this is why it's connected to the previous two slides that we just reviewed. And let's jump over to the expenditures topic, which is often asked about by folks in the field. More specifically, let's talk about how each LEA must spend the following amounts on providing special education and related services, including direct services, to parentally placed private school children with disabilities. So first of all, it's for children ages 3 through 21, an amount that is the same proportion of the LEA's total subgrant under Section 611F of the IDA as the number of private school children with disabilities aged 3 through 21 who are enrolled by their parents in private, including religious, elementary, and secondary schools located in the school district served by the LEA, to the total number of children with disabilities in its jurisdiction, ages 3 through 21. Additionally, it's for children ages 3 through 5, an amount that is the same proportion of the LEA's total subgrant under Section 619G of the IDA as the number of parentally placed private school children with disabilities aged 3 through 5 who are enrolled by their parents in private, including religious, elementary schools located in the school district served by the LEA, to the total number of children with disabilities in its jurisdiction, aged 3 through 5. Appendix B of the regulations provides an example on how to make this calculation, and we have a link at the bottom of this slide to help you navigate there. Go directly right there to Appendix B if you'd like to learn more about the calculation. An accurate count of the number of eligible children with disabilities enrolled by their parents in private schools located in the LEA is needed to calculate the proportionate share of Part B funds that the LEA must expend annually for services for parentally placed private school children with disabilities. As we've already discussed, the regulation in 300.132C require the LEA to maintain in its records and to provide to the SEA the number of parentally placed private school children evaluated, the number to be determined to be children with disabilities under Part B of IDEA, and the number of children who are provided equitable services. This puts an emphasis on the need to maintain accurate and complete records. Let's jump back to another required topic of consultation, which is located at 300.134 paragraph C. This topic is pretty important. It has to do with how to address the consultation process among the representatives of the agency, the private schools, and parents of parentally placed private school children with disabilities, and how it will take place, including how the process will operate throughout the school year to ensure that parentally placed private school children with disabilities identified through the private child find process can meaningfully participate in special education and related services. Again, this is located at 300.134C, and you can click that link if you wanted to pause right now to jump over and see it. The consultation process is important to ensure the provision of equitable services. With that in mind, the LEA must also discuss how, where, and by whom special education and related services will be provided, including a discussion of the types of services, including direct services and alternate service delivery mechanisms, as well as how those services will be apportioned if funds are insufficient to serve all children, and how and when decisions regarding the services will be made. This is located at 300.134 paragraph D, and the hyperlink is in the lower corner, and you could go ahead over there if you wanted to take a look at this in more detail. Well, let's now jump to location of services. Regarding the provision of special education and related services, they may be provided on the premises of private, including religious schools, to the extent consistent with the law. The department interprets the phrase "to the extent consistent with law" to mean that the provision of services on the premises of a private school must take place in the manner that would not violate the Establishment Clause of the First Amendment of the United States Constitution and would not be inconsistent with any applicable state constitutions or laws. And the department generally believes that unless there's a compelling rationale for these services to be provided off-site, LEAs should provide services on-site at the child's private school so as not to unduly disrupt the child's educational experience. The location of services is one of the subjects that must be discussed during the consultation process among the LEA officials, private school representatives, and representatives of parents of parentally placed private school children with disabilities. And after the consultation process, and giving due consideration to the views of the private school officials, the LEAs will make the final decision. We'll talk a little bit more about decisions about which services and the amounts of services children with disabilities enrolled by their parents in private schools will receive. These decisions are made during the consultation process and are based on the needs of the children designated to receive services. Again, based on the needs of the children designated to receive services. Now, these children have no individual entitlement to receive some or all special education and related services they would receive if they were enrolled in a public school. There is a cross-reference to this both in the text here at 300-137 and then also at 300-137 and 300-138. So you'll find all of that information here about the individual entitlement. It's important to understand that provision. And it's also important to note that any unilateral offer of services by the LEA with no opportunity for discussion is not adequate consultation, as such an offer does not meet the basic requirements for the consultation process. It's only after discussing the key issues relating to the provision of special ed and related services with all representatives may the LEA make its final decisions with respect to the services to be provided to the eligible private school children with disabilities selected to receive services. More about equitable services. Equitable services for this population of students must be provided in accordance with a services plan. And a services plan must describe the specific special education and related services that will be provided to a parentally placed private school child with disability who is designated to receive services. This is referenced at 300-138, paragraph B. Additionally, the services plan must, to the extent appropriate, be developed, reviewed, and revised consistent with the IEP provisions located at 300-321 through 300-324. And these are cross-referenced in the regulation at 300-138 for your convenience. If you'd like to stop and pause right now to click over and review the services plan provisions as well as the IEP provisions, this would be a good time to do that. And the LEA must initiate and conduct meetings to develop, review, and revise a services plan for a parentally placed private school child with a disability designated to receive services. The LEA must ensure that a representative of the religious or other private school attends each meeting. If the representative cannot attend, the LEA must use other methods to ensure participation by the religious or other private school, including individual or telephone calls, video calls, email communication, any way that will ensure the participation. And finally, sometimes there will be disagreement about equitable services. At 300-134E, which is the final paragraph under the consultation regulation, if the LEA disagrees with the views of the private school officials on the provision of services or the types of services, whether provided directly or through a contract, the LEA must provide to the private school officials a written explanation of the reasons why the LEA decided not to adopt the recommendations of the private school officials. Well, now that we've finished the consultation requirements at 300-134, let's talk a little bit about written affirmation, which is located at 300-135 in the regulations. When timely and meaningful consultation has occurred, the LEA must maintain documentation that it has occurred, including a written affirmation signed by the representatives of the participating private schools. Some have asked if signing an attendance sheet at a meeting is all that is needed to document adequately that timely and meaningful consultation has occurred. While those attendance sheets provide an accurate accounting of who attended meetings, the sheets themselves do not provide evidence that ongoing consultation has occurred. Therefore, the written affirmation signed by the representatives of the participating private schools should reflect that those officials have indeed participated in timely and meaningful consultation that has continued throughout the school year. If the representatives do not provide the affirmation within a reasonable period of time, the LEA must forward that documentation of the consultation process to the SEA. The next regulation we'll talk about is located at 300.136. And under this regulation, a private school official has the right to complain to the SEA that the LEA did not engage in consultation that was timely and meaningful, or did not give due consideration to the views of the private school official. Under this provision, a complaint must provide the basis of the private school official's belief that the LEA did not comply with the consultation requirements. If a complaint is submitted, the LEA must forward appropriate documentation related to the complaint to the SEA. If the private school official is dissatisfied with the decision of the SEA, the official may submit a complaint to the Secretary, U.S. Secretary of Education that is, providing the basis of the official's belief that the LEA did not comply with the consultation requirements, and the SEA must forward that appropriate documentation related to the complaint to the Secretary. Let's talk a little bit about due process now, which is located in some Part E of the regulations. You can click on the link there in the header that will take you directly to Part E. As provided in Section 300.140B, a parent of a parentally placed child with a disability has the right to file a due process complaint regarding the child find requirements located in 300.131. That includes the requirements cross-referenced in 300.300 through 300.311. Such a complaint must be filed with the LEA in which the private school is located, and a copy must be forwarded to the SEA by the LEA. The due process provisions in Section 615 of the Act and Section 300.504 through 519 of the regulations do not apply to issues regarding the provision of services to any particular parentally placed private school child with a disability whom the LEA has agreed to serve, because there is no individual right to services for such children under the IDEA. The due process provisions are located in some Part E of the regulations as a reminder, so you could click on over there if you find that to be helpful. Disputes that arise about equitable services are properly subject to the state complaint procedures in 300.151 through 300.153. As provided in 300.140C, though, as referenced on this page, a signed written complaint may be filed in accordance with the state complaint procedures alleging that an SEA or LEA has failed to meet the private school requirements, such as failure to properly conduct the consultation process. Now, it's important to note that the public agency must always keep control of and administer the IDEA funds used to provide special education and related services to parentally placed private school children with disabilities. Part B funds for equitable services may not be paid directly to a private school. And the LEA must also hold title to any materials, equipment, and property that might be used by an eligible parentally placed student who receives services under IDEA. Additionally, an LEA may not use Part B funds to finance the existing level of instruction in a private school, and such funds may not be used for meeting the needs of a private school or the general needs of the students enrolled in the private school. Now we've pretty much wrapped up the bulk of our presentation on the IDEA equitable services provisions, but I did want to talk about school choice, as we often get questions about this. And when it comes to school choice, participation in a federal or state private school choice program does not affect a private school student's eligibility for equitable services under an ESEA or IDEA program. So like other private school students, a student is eligible for equitable services if the student meets the program eligibility requirements. Well, this brings us to the end of today's presentation, and here are just a quick summary of our websites where you can link to and go visit. If you want to pause and reflect, you can go visit all of those sites and navigate your way through the information that was provided. But I really want to thank you again for joining me today for this session. Thank you for spending time with me today. My contact information is here, so feel free to reach out if you need to. My phone number is 202-205-9012, and my email address is pamela.allen@ed.gov. If you prefer, you could contact ONPE's main line at 202-401-1365, or you could shoot an email to the main ONPE email address at onpe@ed.gov. Thanks so very much, and I hope that you are enjoying the convention this year and that you are getting all that you expect to out of all the sessions that you attend. Take care and thanks so much.